understand that they were logging into Zoom. I can step out real quick to make a brief call and ensure that they'll be present.
Yes, sir. Thank you.
Give me 1 second now.
All right. So what I'll do is I'll address everybody else. All right. Good morning, folks. Nobody needed a Spanish interpreter? Okay. Thank you. Have a great weekend. Enjoy the game tonight. Take care. All right. So good morning, everybody. Folks, you're here for first appearance. At first appearance, I'm going to inform you of the charge or charges pending against you. I will then determine whether or not there's probable cause for the charge. If I do find probable cause, we'll discuss what conditions, if any, may be appropriate for your release. If I do not find probable cause, you'll be released on your own recognizance. Now, because these are criminal charges, you do have certain rights. You have the right to be represented by an attorney. Even if you cannot afford an attorney, one will be appointed if you ask. You have the right to remain silent. Everything you say is being recorded and may be used against you. I will ask everybody to please stand and raise their right hand. You all solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth.
Yes.
All right, everyone can lower their hands and please be seated. And the state has already announced your presence. I do have a public defender present in the court with me. Please announce your presence. Good morning, ma'am. All right, NJC, was there anybody you are asking to have called out of order?
Yes, sir. Mr. Healy John would be last.
Okay. Anything else?
That would be it, John.
All right, thanks, sir. All right, Melissa Cook. Good morning, ma'am. Ma'am, you're here for a charge of trespass. Would you like to have the public defender represent you in this case?
Yes.
I want to appoint the public defender at this time. I reviewed the probable cause affidavit. I do find probable cause. Ma'am, you have a pending trespass charge from the exact same location. I couldn't help but take notice of that. Bond in this case is going to be set at $2,000. You may not return to the Naples Garden Inn at 2630 9th Street North in Naples, Florida. And state, do you have a motion at this time?
Yes, sir.
All right. The motion is granted. Yes, ma'am. Just, I don't need a written motion, especially since I have no clerk here to hand it to. You can just do an or tennis motion. It's sufficient. All right. No, that's okay. All right, ma'am. So because I found probable cause that you committed a new offense, I've revoked your bond in your pending case. Good luck to you, ma'am. All right. Joni Gibson. Good morning, ma'am. Ma'am, you're here for a charge of battery. Would you like to have the public defender represent you? Would you like to represent yourself? Okay. All right, I reviewed the probable cause affidavit. I do find probable cause. State, this is considered a domestic violence case. Do you have information provided to the court at this time?
Your Honor, per section 741, 2909, section 3,
All right. Having found probable cause, bond will be set as follows. Bond is set at $2,000. You may not have any contact with the alleged victim. That name will be provided to you in a written order. You may not return to the Red Roof Inn in 1925 Davis Boulevard in Naples, Florida, except you may return one time with a law enforcement officer to retrieve any personal items. Now that's for your protection as much as it is for his. You may not possess any firearms, and if you have any, they must be turned over to the sheriff's office within 24 hours of your release. Good luck to you, man. All right. Misty McKinney. Good morning, ma'am.
Morning.
Ma'am, you're here for a charge of obstruction of a law enforcement officer. Would you like to have the public defender represent you?
Yes.
All right, I'm going to appoint the public defender at this time. I reviewed the probable cause affidavit. I do find probable cause. Bond in this case is set at $2,000. However, I couldn't help but notice you have a pending charge, a pending felony charge, 19 CF 1135. State you have a motion.
Yes, I'll stick with the policy motion to revoke for AROSE in that case.
Was he was ROR'd in that case?
Yeah.
Was that done at first appearance, or was that?
I've been going to court with that for over a year. I'm not a flight risk or anything like that. It's been a long going case.
Give me a moment. Oh, there we go. They've just signed in.
Okay.
All right. Hello, Collier Detention Center. Give me one moment. I'm just addressing one case, and I'll be right with you, folks. Okay? Give me just a moment, please. Oh, that's what I'm considering, ma'am. I'm considering whether or not I'm gonna hold you without bond or not. Give me just a moment.
All right, yes, sir.
Bonds were set originally. There's a bench warrant. Bench warrant back in August.
Been showing it before and every time for over almost 2 years.
It was her. It was a referral to diversion. Deferred prosecution. One moment. All right, there was a previous failure to appear in the felony case. The reason for the ROR is because she was offered diversion, 6A diversion. She failed to successfully complete 6A diversion because of a finding that she had willfully did not complete certain terms, including failure to report to probation to complete 6A diversion. Therefore, the state's motion to revoke bond in 19 CF 1135 is granted. That means, ma'am, you're going to stay in custody until at least until your felony case is resolved, or unless Judge Mineleach is willing to give you a bond in that case. Good luck to you, ma'am. All right, Emma Perez. Good morning, ma'am. All right, I'm sorry. I'll do your case next. All right, ma'am. You're here for a charge of leaving the scene of a crash. Did you wish to have the public defender represent you?
Jesus, man, it's your
All right. Well, does anyone have Eduardo's phone number? Tell her to hold on just a moment. You have his number? Yeah, would you please call him? Thank you. Yes, sir. That'd be fine. All right. While we do that, let me go ahead and address the juvenile case. All right. So this is Mr. Semi. Did I pronounce that correctly?
Yes.
All right. And I do have an officer from DJJ present. Please announce your presence. All right. Good afternoon. Good morning. And good morning, sir.
Good morning.
We are here for alleged violations, tampering with electronic monitoring, violation of home detention, and violation of probation. I reviewed the probable cause affidavit. I do find probable cause. It looks like the juvenile scores. I'm sorry, before we go any further, I apologize. Did you want to have the public defender's office represent you, sir? Or do you already have an attorney?
Say it again?
Would you like to have a lawyer help you?
No, I'm good.
No, you don't want a lawyer?
No, I want a lawyer.
All right, now you do have a right to have a lawyer, and there is an attorney, a public defender in the court with me. Would you like her to assist you today?
No.
Okay. All right, did we have the ability to contact a parent?
The parent was attempting to be notified at 10 p.m. last night, 1 o'clock, 3 o'clock. The show got set up, so we couldn't make contact.
All right. All right. In an abundance of caution, I'm going to provisionally appoint the public defender's office since there's no parent present. I know you said you didn't want a lawyer, sir, but just to protect your interests, I just want to make sure that I do that. Okay. You don't have to have a lawyer going forward, but without a parent here, at least you'll have a lawyer looking out for your interests. You are. All right, very good. All right, so as I was saying, I did review the probable cause affidavit, and I do find probable cause, however. It looks like he scores 14 points, which does qualify him for secure detention. Is that correct?
That's correct.
All right. Counsel, would you like to be heard? All right. Do you have an order then? It's 21-day secure detention?
That's great. Yeah. Also, over at his place, if possible, we consider review for tomorrow, at 9 a.m. just the violation of probation.
Yes, sir. Does Judge McPhee do reviews any other day? Just because Monday mornings or?
I do have another one that I think of two.
Can I do Tuesday, please?
Yeah.
Thank you, sir. I think that it's just Judge McPhee and knowing what's coming, and he can be a little more prepared.
Absolutely.
All right, thank you. Perfect. All right. Mr. Semi, did I pronounce your name correctly?
Yes, sir.
Mr. Semi, you're going to see Judge McPhee on Tuesday morning, okay? DJJ, I imagine, is going to continue to try to reach out to, see if we can have a parent present for you.
Yes,
and Judge McPhee will see you then, okay?
McPhee, you gonna see me on Tuesday, you said?
Yes, sir.
At what time?
At 9 o'clock. All right?
But I had a court date. I had a court date on next Monday. Do I still have that?
I can can verify that as well. I'm not sure but I can verify.
All right. Well, I don't think this, well, you're his attorney on that.
It appears the other way is set on the 6th.
Okay, so next Monday, not this Monday, but the following Monday. All right, so you'll see Judge McPhee before then, and you might be able to address another matter at that time. No, sir, I don't. Thank you. All right, good luck to you, young man. All right, thank you, sir. All right, switching back. Were you able to reach Eduardo? All right, let's, you had was that his cell phone number you were calling? Can you text him, please? Thank you. Let's hold on to Ms. Perez. The court interpreter told me that he had asked if anyone needed his services and was informed that they did not. So he left. Let's see if we can get him back. We'll try to reach him. Thank you, Corporal. All right, so we'll see Ms. Perez in a moment. We'll see if we can get our interpreter back. If not, I'll just use language line. Rigoberto Borrego Amaro. He bonded? All right. Bobby DiMartino.
Good morning, Your Honor.
Good morning, sir. All right, sir, you're here for violation of probation on 2 cases out of Lee County, and they were 18 CF 19594 and 18 CF 19598. I believe I appointed a public defender yesterday to help you. Is that correct?
That is correct. And yesterday you said I could state something before you make a decision.
Yes, sir. I certainly will do that. Give me just one moment. I'm going to appoint the public defender once again. Given that I did find probable cause for the new criminal offense, I do find probable cause for the violation of probation. Now, yes, sir. I will definitely give you an opportunity to speak if you want to talk about, because now's the time to talk about whether or not I should set bond on these cases. Go ahead, sir.
Yes, sir. Currently, I'm diagnosed with stage 3 gastric cancer. I also doing bi-weekly chemotherapy sessions. Never violated probation in the past. Never had a failure to appear. I would request that I either be placed on maybe house arrest with limitations for me going to chemotherapy, since I do not receive a flight risk.
State, would you like to be heard?
Yes, Judge. The limited act issued in both cases out of the county case. No bond issued in the fact that.
What do you mean? I'm the one who issued them.
Oh, sorry. Well, based on the nature of the offense, Your Honor, it's grand theft in the same case that we can only just ask that you set the standard bond for both offenses in both cases.
What's the standard bond for BOP?
For the BOP, low BOP, Your Honor, the state was the first report on a government bond.
Sir, here's my concern, and I will give counsel an opportunity to respond as well. My concern is that you're on probation for a scheme to defraud, and I had a chance to look at your Fort Myers cases. It's a scheme to defraud and grand theft with multiple victims. The new charge alleges another grand theft in a somewhat sophisticated scheme. You kind of put me in a tough position here.
I do have evidence, Your Honor, to prove otherwise, but the detective didn't want to see anything. He told me to stay before the court, and I turned myself in as the officer requested.
No, I read the probable cause affidavit, sir. I said it really does put me in kind of a tight spot. What is the jail's ability to provide medical treatment for someone who's receiving chemotherapy? Are we able to provide that kind of medical treatment?
That's something I'd have to get with the medical staff here, Your Honor, and get with them if he's not eligible to bond out. I'd have to get with our medical staff.
Sir, when is your next treatment scheduled?
Wednesday, sir.
Wednesday?
Yes, sir. And right now, there is medication the jail is not providing to me at the moment because they don't have the medication.
All right. Yes, counsel.
Your Honor, I would just point out that under 9.8 section B, it is a bank, so you do have the ability
I agree.
to get some bond based on extenuating circumstances. I don't know the specific policy of the sheriff's office, but I believe that they would have to transport him back and forth to the hospital based on the current pandemic as well. I would believe that would cause
Sure does.
issues also for the sheriff's office and the ability to transport, not to mention the how. And again, this is a bit of an assumption. I don't know specific policies, but the ability to go in and out of the hospital or the treatment center where there's people that are at extreme high risk of the virus based on circumstances. He did comply as your honor, review the probable cause affidavit. He was in compliance with the detective on the case throughout the investigation, and he did turn himself in. I do believe that he is potentially represented by a private entity. However, my opinion this morning, I would ask that you set a bond in this case. It would ensure that he's going to show. If he does not show support, then his bond will ultimately be revoked. And given the specific circumstances with chemotherapy treatment, I don't believe the jail is the appropriate place to appropriately administer his medical at that time. Request that you set a bond.
It's doing first appearances tomorrow. Judge Nicola. All right. Sir, are you able to afford to post a bond?
I have family that are helping out. Yes, sir.
One moment. All right, here's what I'm gonna do. I'm gonna hold you till tomorrow. I'm going to reach out to jail administration and find out, number one, what sort of medical treatment they're able to provide. I'll make sure that I communicate our discussions with Judge Nicola, who's going to see you tomorrow afternoon at 2 o'clock. Sir, are you able to provide the public defender's office with any information, someone they can speak to who can confirm your medical condition and provide that to either the court or the jail?
I had my attorney, which I don't know why he's not present today, Michael, and he requested on my own record to perform. I didn't see any position here in the county.
Okay, Mike Chernopoulos is your attorney?
Yes, Your Honor.
All right. perhaps I might be able to have a brief conversation with the state and Mr. Chernopoulos about this and see if he's able to obtain that information as well and provide all that to Judge Nicola for first appearance tomorrow. All right, so I don't feel I have enough information at this point to make a decision as the appropriate bond. Therefore, sir, I think it's best that I return you to first appearance tomorrow afternoon. We'll collect a little more information and then we can make an appropriate decision at that time, okay?
Yes, Your Honor.
All right. Robert Flynn. Good morning, sir. Sir, you're here for a charge of DUI. Would you like to have a public defender appointed to represent you?
Yes, please.
All right, we're going to appoint the public defender at this time. All right, I reviewed the probable cause affidavit. I do find probable cause. Bond is set at $1,000. Good luck to you, sir. Jean Fortin. Good morning, sir.
Good morning, sir.
Sir, you're here for a charge of resisting an officer without violence and a charge of possession of marijuana less than 20 grams. Would you like to have the public defender's office represent you?
Yes, sir.
I'm going to appoint the public defender's office at this time. I have reviewed the probable cause affidavit. I do find probable cause on both counts. Bond is set at $2,000 per count. Good luck.
Your Honor,
Oh,
I would like to say,
one moment. Your attorney is standing up to address me. Go, one moment, sir, and I'll give you a chance to speak. Okay?
sir,
Sir, I would just point out that I didn't see anything on the board for the document that indicated that there was a question as to that based on the law, I would argue that there's not compromise because the substance is marijuana charge.
See?
Judge, while the state would agree with the defense counsel argument as to the four corners of the complaint, when the defendant was stopped, he was stopped because of a traffic violation on the bike. That doesn't prevent the court from finding probable cause until defense counsel argues that the motion that should be brought in the future.
Well, the argument is that it's not PC because they didn't inquire whether or not he could otherwise lawfully possess the marijuana. That's the argument.
And the state would agree, Judge, there is nothing to give
Except generally speaking, you know, I don't think there's anything in the law that at least I haven't seen anything that requires an officer to ask, do you have a prescription for this? Number one. Number two, the fact that he is throwing it on the ground as he's running from a law enforcement officer would indicate it's highly unlikely that it was possessed lawfully, right?
Well, Your Honor, there was also money thrown and as indicated in the UK.
Yeah.
So I would disagree with the court on that aspect. As far as whether or not he asked there being a rule requiring me to, I'm not sure that there's a specific rule as to that question. However, as the law has been changed as of July 1st of 2019, the field test would not be able to distinguish between hemp or THC in a psychoactive analysis. So I believe for purposes of probable cause, they cannot indicate that this was possession of marijuana because they have done nothing to show that it is actually marijuana.
Judge, if I may,
Okay.
even if the question wasn't posed in the form of the complaint, the officer did field test the marijuana itself, and
Right.
it did test positive for THC.
Right, but the argument is so does hemp. Okay. All right. Fair enough. No PC on count 2. That'll be ROR. Because there doesn't appear to be any inquiry or other evidence that this was in fact marijuana rather than hemp. All right. Good luck to you, sir.
Yeah.
But yes, sir. Yes, sir.
So I'm only being charged with the resisting without violence?
No, sir. Right now, you're still charged with both. And if the state can obtain other information to bring forward both charges, they can bring both charges. All I've decided is that there's not enough information in the probable cause affidavit for me to find probable cause on the second count. So I'm going to release you on your own recognizance on that count. There's no bond that you're going to have to pay to get out on that count. Just the resisting charge, okay?
Sir.
All right, so you do have an arraignment though on both counts on March 4th, and you'll have to appear then, all right?
Yes, sir.
All right, good luck to you, sir. Take care.
Thank you.
Scott Holdsworth? All right, good morning, sir. You are here for a charge of battery. And would you like to have the public defender's office represent you?
Yes, sir.
I'm going to appoint
Yes,
public. All right, no problem. I'm going to appoint public defender's office at this time. I have reviewed the probable cause affidavit. I do find probable cause. State this is determined to be a domestic violence case. You have information provided to the court at this time. All right. All right. Having found probable cause, bond will be set as follows. Bond is set at $2,000. Or, sir, you do qualify for pretrial release. And what that means is that you don't have to put up any money in order to get out of jail today. But regardless of whether you decide to pay the bond or sign up for pretrial release, you have to abide by the following conditions. You may not have any contact with the alleged victim or the witness who were listed in the probable cause affidavit. You may not return. Actually, no, I'm not going to do a no trespass order. However, I am going to order that you may not possess any firearms. And if you have any, they must be turned over to the sheriff's office within 24 hours of your release. If you do sign up for pretrial release, sir, you'll have to abide by the additional condition of having a GPS monitor and staying at least 500 feet away from the alleged victim at all times. Good luck to you, sir. Yes, ma'am.
Given that the alleged victim in this case is a minor child, I would request that the contact be to follow the dependency that we initiated the victim's death.
At this point, it would be because I don't know what the status of that is. It's not even an open case yet. Normally, in order to do that, I put in my order, must abide by all orders and conditions in case number X, Y, and Z. Since I don't have that ability, it's my preference to do it, just a no contact order at this time. And I don't know what charge will be assigned to the case, but I would feel it's entirely appropriate to amend the no contact order to track the dependency action if one is brought, to be more flexible with contact. So I would encourage counsel to file that motion, as soon as there is a case to refer to. Because I agree with you, that is the best way to do it. I just don't have a case to refer to at this time. All right. Juan Jasso Lopez.
Court, sir.
I'm sorry?
sir.
Oh, good morning. All right, sir, you're here for a charge of battery. Would you like to have the public defender represent you?
Yes, sir.
I'm going to appoint the public defender at this time. I have reviewed the probable cause affidavit. I do find probable cause. I state this is a domestic violence case. Do you have any information to provide to the court at this time? All right. Do you have a disposition on that? Very well. All right. Now, sir, there's a couple things. I did notice that you're currently on bond in another felony charge in Polk County.
Yes, sir. Yes, sir.
And because I do think a heightened bond is appropriate in this case, bond in this case is $5,000. You may not have any contact with the alleged victim. If, I'm sorry, you may not return to the address where this is alleged to have occurred except for one time to retrieve any personal items. And if you do that, it must be with a law enforcement officer that is as much for your protection as it is for hers. You may not possess any firearms, and if you have any, it must be turned over to the sheriff's office within 24 hours of your release. I'm giving you the heads up, sir, about the charge in Polk County because the state up there may choose to revoke your bond in that case. You may want to speak with counsel about what that might mean for you. Okay.
Because I'm supposed to be reporting to the ombudsman every Tuesday and every Monday to pretrial. So then I got court on March. So if I don't bond out, what's going to happen? I'm also not going to bond out. I'm just going to,
Well, that's the thing you're going to need to talk to your lawyer about. When if you get a lawyer in this case, you're going to need to talk about whether or not it's in your best interest to bond out and how to deal with the case up there. Okay.
Yes, sir.
All right. Good luck to you.
Thanks, sir.
All right. Corey Patrick Lavallo or Lavallo. Good morning, sir.
Lawyer,
How do you pronounce your last name?
Lavallo.
Lavallo. Thank you. I won't mispronounce it again. All right. So you're here for an alleged violation of probation. And it's alleged as follows: that you did not pay your monthly probation fee each month, that you failed to pay fines and court costs, that you failed to provide proof of receiving a substance abuse evaluation, and you failed to provide proof of completion of an anger management course. Well, these are the allegations, sir. Would you like to have a public defender's office represent you?
Yes, please.
All right, I'm going to appoint the public defender at this time. I've reviewed the warrant. I do find probable cause in both counts. Judge Adams determined that you should be held without bonds. So accordingly, bond is set at no bonds. Good luck to you, sir. Thomas Maxwell Macaulay Schmidt. Is Mr. Macaulay Schmidt available? And JC? Oh, there we go.
Yes, sir.
All right. Good morning, sir.
Morning.
Sir, you're here for a charge of DUI, a charge of possession of paraphernalia, and a charge of refusal to submit to alcohol testing. Would you like to have the public defender's office represent you?
I talked to Giovanna yesterday.
Yep.
And she wasn't available for Monday, so I don't know if we should offer another day.
Yeah, I can do that. Yes, sir. I can return it. I can return it to tomorrow.
Make Tuesday be best. Yeah.
I would feel safer returning you to tomorrow. Ms. Upson is usually out and about in the courthouse every weekday.
That's fine.
All right.
Thank you.
Yes, sir. Return to 24th. All right. John Million. Mr. Million? All right. Good morning, sir. Sir, you're here for a charge of battery. Would you like to have the public defender's office represent you?
Sir.
I'm going to appoint public defender at this time. I have reviewed the probable cause affidavit. I do find probable cause. State, I believe this does qualify as domestic violence. Do you have information you provided the court at this time?
Yes, Judge. The defendant has been arrested for TV battery back in 2014 in communication with the felon. And in 2019, he was arrested for battery, but the state was lost that charge.
The one in 19 was null pros.
I believe so.
The NCIC shows a conviction. One moment. Nope. It will be, you know, NCIC sometimes aren't 100% correct. I would rely more on, you know, your records or the clerk's records. Let's take a look.
That is correct. And there was an adjudication of guilt back in 2019. Had it on.
Okay. All right. So given that this is potentially can be charged as a felony offense, well, first of all, having reviewed the probable cause affidavit, I do find probable cause. And once again, given that this could potentially be a felony offense, and also in consideration of your other prior history, sir, bond will be set at $10,000. You may not have any contact with the alleged victim. You may not return to the home address that was indicated that is shared by the parties, except for one time to retrieve any personal items. And if you have any, if you do decide to go back there, you must go with a law enforcement officer to protect your interest and safety as much as it is hers. You may not possess any firearms. And if you have any, they must be turned over to the sheriff's office within 24 hours of your release. Good luck to you, sir.
I got one question.
Yes, sir.
Why is my experience, sir?
I'm sorry?
I thought it was sir.
I'm sorry, I didn't understand the question.
I said, you guys didn't have a felony, this time a felony, why do you have a felony for?
No, the state can charge you with a felony on this offense because this could be charged as a second or subsequent battery, which is a felony offense. Right now, it's charged as a misdemeanor, but the state can opt to charge it as a felony.
Okay, well, the victim moved out last night and I can't show back to my house.
Well, I don't have that information, sir. So my order is going to stand for now. All right. All right. Good luck to you, sir. Finwick Paul. Good morning, sir. Sir, you're here for the charges of possession of controlled substance, possession of marijuana less than 20 grams, and possession of paraphernalia. Would you like to have the public defender's office help you today?
I have a public defender, but he's on today, sir.
So yes, you would like a public defender today? I'm going to appoint the public defender at this time. I reviewed the probable cause affidavit. I do find probable cause on all counts. Sir, bonds are set as follows. Count 1, 5,000, count 2, 2,000, count 3, 2,000. But I've been informed that you qualify for something called pretrial release. And what that means is that you don't have to pay any money in order to get out of jail today, okay? However, if you want to sign up for pretrial release, you're subject to random drug screens, and you'll have to check in with pretrial services when they tell you, okay?
Sir.
All right, good luck to you, sir. Christopher Prasad.
Yes, sir.
Good morning. Sir, you're here for a charge of aggravated battery. Would you like to have the public defender help you with your case today?
Yes,
I'm sorry, what was that?
yes, sir.
All right, I'm going to appoint public defender at this time. I have reviewed the probable cause affidavit. I do find probable cause. This is deemed a domestic violence case. State, do you have information you provided the court at this time? Thank you, ma'am. All right, the bond in this case will be set at $5,000. You may not have any contact with the alleged victim. You may not return to the address that's indicated that you have in common with the alleged victim, except for one time to retrieve personal items, and that must be with the company of a law enforcement officer. You may not possess any firearms, and if you have any, they must be turned over to the sheriff's office within 24 hours of your release. Good luck to you, sir. Vidal Rendon. Good morning, Mr. Rendon. Sir, you're here for a charge of trespass. Would you like to have the public defender's office help you today?
No.
All right. You want to represent yourself?
No, I'm not representing.
All right. Well, I don't have any attorneys in the court with me other than the public defender's office. So you can either represent yourself or you can have the public defender's office today. What would you like to do?
All right, well, sign it.
All right. I'll provisionally appoint public defender's office for today's proceeding. I've reviewed the probable cause affidavit. I do find probable cause. Bond is set at $2,000. Return to the Circle K at 6615 Dudley Drive in Naples, Florida. State, you are standing up.
Yes, Judge. The defendant the case in the county, case in the state
It's interesting, the jail didn't give me that. Did the jail miss it? Did I miss it? Hang on. May I get that case number again, please?
Yes, Judge.
Yep.
635.
Huh. All right. Counsel? Apparently it does appear to be him. Looks like it's a charge of public intoxication. Counsel? What's that?
I just take a picture on.
Yep.
Based on the second period, that a bond, it doesn't appear that Phelps was here at any of the court dates.
All right. Given the I understand, but nonetheless, state's motion is granted. All right, sir. Good luck to you. All right, Mark Snow.
Yes, good morning, Your Honor.
Good morning, sir. All right, sir, you're here for a charge of battery. Would you like to have the public defender's office represent you?
Yes, please.
Appoint public defender at this time. I reviewed the probable cause affidavit. I do find probable cause. State, I'm going to ask you to comply with your statutory obligations, but I would point out that, Mr. Snow, you have the misfortune of having a judge right now with a good memory. I remember you from a few months ago when I saw you under very similar circumstances. So go ahead, State.
Yes, sir. The defendant was arrested back in 2020 for state offense, however, the state charged.
With the same alleged victim.
Yes, sir.
All right. All right, bond in this case is set at $10,000. You may not have any contact with the alleged victim. You may not return to the address, which is indicated in the probable cause affidavit, except for one time to retrieve personal items. And if you do, you must do so with a law enforcement officer. You may not possess any firearms, and if you have any, they must be turned over to the sheriff's office within 24 hours of your release. Good luck to you, sir.
Thank you.
William Tang.
He is in NCA right now, Your Honor.
All right. I'm going to go ahead and proceed in his absence because he'll come back tomorrow anyway. All right. He's here for 4 counts of aggravated assault with a deadly weapon. I've reviewed the probable cause affidavit. I do find probable cause on all counts. Bond is set at $10,000 per count. He may not have any contact with the alleged victims. He may not return to the Mercado at 9114 Strata Place. May not possess any firearms. If he has any, they must be turned over to the sheriff's office in 24 hours of his release. And State, you have a Woodman warrant prepared?
Yes, sir.
All right. I'm going to issue a Woodman warrant in that felony case. He'll be brought back before the court tomorrow if he's if he's otherwise healthy to do so. Thank you, sir. Matthew Valencia.
Is it David? Sorry, Your Honor.
I'm sorry, who is this?
He is at David Lawrence, Your Honor.
All right.
Yes, sir.
So who do I have before me? Is this Mr. Healy?
This is yes, Your Honor.
All right, let me go ahead and address Mr. Healy, and then I'll address Mr. Valencia. All right. Good morning, Mr. Healy.
Good morning, Your Honor.
Sir, you're here for a charge of battery on a person 65 years of age or older, and a charge of grand theft. All right. Would you like to have the public defender's office represent you?
For today, yes, because the private attorney contacted yesterday, no problem with that tomorrow.
Okay. All right. So you still want to go forward today and then retain private counsel? Is that right?
That's correct.
All right. Very good. Then I'm going to provisionally appoint public defender's office at this time. I've reviewed the probable cause affidavit and State, it's entirely possible that I missed it. Is there a mention of the alleged victim's age anywhere in the PC affidavit? So I will freely admit that sometimes I miss this, but
I don't see it.
I don't see it either.
Judge, I do not.
All right. All right, then I find PC for the lesser of simple battery. And so bonds will be set as follows. Count 1, bond is set at $2,000. Count 2, I do find probable cause on count 2, bond is set at $5,000. You may not have any contact with the alleged victim. You may not possess any firearms, and if you have any, they must be turned over to the sheriff's office within 24 hours of your release. Good luck to you, sir.
Thank you.
let me go ahead and address Matthew Valencia, which is charge of carrying a concealed weapon. I'm going to go ahead and proceed in his absence. I have reviewed the probable cause affidavit. I do find probable cause. Bond is set at $2,000. In state, you have a Woodman warrant?
Yes, Judge. I have a witness warrant for case number 19.
Wouldn't happen to know if that case is in front of Judge Martin, would you?
I can check for you briefly.
Yes, please. Because if not, from what I saw in probable cause affidavit, this may be appropriate for, you know, fast track case for consideration by the courts.
I would just argue that he was at his home at the time and under 790.25, that would all.
Except for when he came out.
I'm sorry?
790 point.
25, subsection 3, subsection.
All right, say it again, please. 790 point.
790.25, subsection 3, lawful uses, subsection N, a person possessing arms at his disposal. Also, a concern.
790.053.
Not valid.
790.06.
However, to be candid, I was unable to assume whether or not he had been keeping on.
Yeah.
Judge, I do have the assigned, I have the information for who the assigned judge in the case, next to you.
And?
And that is, Judge Ross.
Huh. All right. My finding of probable cause stands. However, bond will be set at ROR on the new charge, but I am going to issue the Woodman warrant. I am also going to, I didn't say this, but I am provisionally appointing your office to represent him. Did you already represent him on the felony? You know, it may be appropriate that he get released on this, but I think for his safety, I feel a whole lot better issuing the Woodman warrant at this time and allowing your office to do a thorough review and see which is the best path for him to present that to Judge Foster. But at least if it's appropriate that he be released on this VOP, the new charge won't hold him either. All right. Okay, so we have Ms. Perez. And do we have any luck reaching the bottom? All right, I'm going to try to call language line.
Welcome to Language Line Solutions. Please enter your 6-digit client ID. For Spanish, press 1. For please enter your access code file resident. Please hold for an interpreter. Please continue to hold for the next available interpreter. Please continue to hold for the next available interpreter.
Do you know which one of your colleagues is doing 24s tomorrow?
I don't know this one, Your Honor, but I can find out before tomorrow. She is a trial, but I understand.
No, I don't mean Miss Perez.
Oh.
The gentleman who
Please continue to hold for the next available interpreter.
he says he needs to go to his chemotherapy session. I was
Oh,
hoping to get a representative from the SAO and the PD. Well, actually, no, I'm sorry. He said Mr. Chernobyl, but private counsel. That's right. I'm sorry.
But I will say,
Just in case we can't reach Mr. Chernopoulos.
Please continue to hold for the next available interpreter.
We'll give it another minute or two, at which point I'm just going to release Ms. Perez. She qualifies for PTR. Is there anyone in the jail who could do a little bit of Spanish translation for us?
I can try to find one, Ron. At the moment, they're serving chow, but I can see if I can find
Oh,
somebody.
I'd appreciate it. I'm sorry to, our interpreter, he left a little prematurely.
Available interpreter.
I just want to be able to tell her she can get out of jail today. All right.
Yes. Please continue to hold for the next available interpreter.
Yesterday was the phone. Today he bailed on us. Eduardo and I were gonna have a chat. For the record, I'm kidding. I'm not angry with him, but I do fully intend to make fun of him for this.
Yeah.
Please continue to hold for the next available interpreter.
It happened to us a couple of weeks ago.
Really, where you ask if anyone needs help, everyone says no.
Yeah. And then
Yeah,
just,
I went to jail with those checks that you are.
Fantastic. Thank you so much, officer. I appreciate you helping us out.
No worries.
All right, so this is Miss Perez. Let me just go through this pretty quick. Would you ask her if she'd like to have a public defender help her?
Yes.
All right. I'm going to appoint public defender. Please tell her she's here for a charge of leaving the scene of a crash.
Ok, estás aquí en el caso de ítem en caso de un accidente.
All right.
I was told.
Okay. I do find probable cause. Please tell her that her bond is either $500 or she qualifies for pretrial release. So she can get out of, so let her know she can get out of jail today without paying any money. And I assume you guys have somebody who speaks Spanish in pretrial services who can let her know what she needs to do.
Yes, Your Honor.
All right. All right, please let her know.
Thank you. I'm going to do that work with you also this is okay, but we'll take it from the answer.
I would just request
Oh, the only condition is the check-in. Okay. I think they do instruct them when they sign up for pretrial, right?
Correct.
Okay. So the only check-in for pretrial release is that you have to check in with them by phone.
La única cosa que va a tener que decir que tú vas a empezar con te va a dar las condiciones para que te salgan de ese programa. Okay?
All right. All right. Good luck, ma'am. Thank you, Kyle. Thank you, Deputy. I appreciate it. Thank you, NJC. And I think we're in here. All right.